Some new details in the trial of the graduate of an elite prep school who's accused of raping a 15-year-old freshman when he was a senior. Owen Labrey is 19 now. He's accused of luring the girl to the school roof as part of a tradition where senior men try to have sex with freshman girls. During testimony yesterday, one of Labrey's friends said that he warned him against trying it. Listen.
He told me he was going to see. I was on my way. I believe I was on my way to my sister's trumpet concert, and he was on his way to spend time with and I told him that it probably wasn't a great idea, and I warned him that she was a lot younger than us.
Is that what you meant by probably wasn't a great idea?
Yeah, that was.
Joining us now, Lise Wheel, a Fox News legal analyst. Dan Schorr is a former prosecutor. To you first, Lise. Labrey has apparently said this was consensual sex. There was no force involved. How do prosecutors try to get around that?
The prosecutors have to get around that by putting on witnesses just like we saw yesterday, that say, look, you know, he was enticing her, he wanted her to be there. He did say that he had sex with her to us, the friends. At least two friends have said he told us he had sex. And don't forget, that right there is statutory rape because he at the time was 18 and she 15. The prosecution has the burden of proof, though, and here they don't have a rape kit, they don't have physical evidence. That's problematic for the prosecution.
Labrey's attorneys, Dan, have said that he is likely to testify in his own defense. Is that going to be effective? I mean, normally in a criminal case, you don't want your defendant on the stand, your client.
Right, but in a consensual sex defense case where the defense is saying it was consensual, often you do see them testify because otherwise you just hear the victim's version. Now, the victim was cross-examined pretty harshly by the defense, but the defendant obviously feels he needs to give his version. It's important to note there's two issues here. One is, did they have sexual intercourse? As Lee said, that would be illegal just because of her age. And then there's the question of whether she was trying to stop him from having sex with her, and then there would be the forcible rape conviction. That would be a higher felony, and he would face even more prison time.
She says that she was raped, and that she was, you know, that she was saying no all of the time, that she was overwrought and upset and all about it. The problem, for the prosecution, is she didn't immediately go get a rape kit. She didn't immediately seek attention. That's problematic for the prosecution.
But that's common with a lot of rape cases.
Right,
where victims feel they worry, they don't know how to report it, they're concerned, they're scared, they're shamed.
But she also had, you know, exchanged emails with him afterwards, this event, and they were, you know, kind of benign, maybe even friendly emails.
You know, though, that sounds so strange, but that does happen in real rape cases, that it's almost a denial. Like, I can't even believe that this actually happened to me, so you don't get medical help, and you do send those emails. I've seen that happen before, as strange as it sounds.
Now, the charge against him is sexual assault right now. You're saying that if they had consensual sex, it would have been a lesser charge.
Exactly, it would be a lesser charge, but that's it. She was 15, he was 18. If they had rape, whether they had sex, whether it was rape or consensual, that would be illegal.
And her testimony on the stand was apparently pretty convincing.
Well, it was really powerful. She told what happened on the stand. She said that she looked up to him as an upperclassman. She was flattered. She wanted to have limited contact, maybe kissing, and that he went farther. And that happens in a lot of rape cases where someone consents to a little bit of activity but doesn't want to have sex, and then the attacker pushes on.
And now the defense will have their opportunity with the defendant up on the stand saying exactly that, as Dan is saying. For her being emotional, now he'll be emotional about saying exactly the opposite.
And this case drawing so much attention in part because St. Paul's School, where it allegedly took place, is, you know, where senators and members of Congress and governors and
you send your kid to a place like this.
John Kerry went to.
You know, yeah.
All right, let's turn our attention to another case in the news. The illegal immigrant charged with killing a woman who was just walking on a San Francisco pier. He is due back in court today. Juan Francisco Sanchez is accused of shooting and killing 32-year-old Catherine Steinle back on the 1st of July. The preliminary hearing will determine if there's enough evidence to try him for murder. His attorneys are saying, Dan, that this was just an accident, that he picked up this gun and it automatically started firing by itself. But they don't really have to present a lot of their case today, right?
Right. The standard is only probable cause. Can the prosecution show this probable cause to move on to trial? That's a much lower standard than beyond a reasonable doubt. So the prosecution will definitely meet that burden, the probable cause today, and then it'll move forward to trial. The accidental defense, you'll see that later on when it goes to trial or when there's motions.
But sometimes defense is looking for mistakes that the prosecution
Exactly.
makes or inconsistencies in testimony that come out of preliminary.
Prelim is exactly, it's like a mini trial. It's a fishing expedition for the defense. They want to glean everything they can from the prosecution while at the same time giving pretty much little or nothing to the, to show what their defense is going to be. Now, the idea that he just happened to pick up this firearm that just happened to be wrapped in a blanket, it happened to just go off on its own, I guess that's all they've got to work with.
Yeah, and he has given conflicting stories, Dan, Sanchez has, as to exactly what transpired when this bullet left the gun and killed Catherine Steinle.
Right, because it's not in dispute that he shot and killed her. So what can he say? He could maybe say self-defense, but there's no evidence of that. He has to say it was an accident.
He said he was shooting at sea lions and the gun just kind of went off.
Right, he has to find some explanation, and obviously he's having a hard time finding a consistent and credible one.
Well, that's what defense lawyers are for. They'll come up with something. I mean, I'm serious. They will come up with it, whether it's accidental, whether it's shooting at sea lions, whatever. They've got to come up with something, and today's the day where they can try to find out exactly what the prosecution has. And you know what? It's pretty much out there. It's pretty much, we know what the situation was. And the father, don't forget, was right there.
Can the defense attorneys argue in any way that the federal government or maybe the local government was somehow responsible for this girl's death because this guy had been deported 5 times and kept sneaking back into the country?
Not as part of their criminal case. What you touch on is a very important public policy issue, but in terms of the criminal prosecution, that doesn't help the defense at all, and I don't think it's relevant for the prosecution
No, there's
either.
immunity on the state and the federal side anyway. But
So they can't say, look, this guy should never have even been on this pier if the federal government or the local
good luck.
government
They
had
can
been
try. I
doing
mean,
this.
defense
that
will
won't
throw
be
anything out,
helpful
but that
at
won't be helpful. But out of this, fortunately has come the idea of Kate's Law, and it's looking good in many states. We're going to pass Kate's Law and federally. That would be really the right thing to come out of this tragedy.
Yeah, you really feel for her parents. It has been so sad to see this family just devastated by what happened that day. Lee's Wheel, Dan Schorr, thank you both.
Thank you.